also tell them that we're going to be on the record since there's no green light.
Where do you want to call?
The court reporter to let her know to put on the record.
I don't know the court reporter's
6214. No, that was the. Well, I'm not sure if I got the right number.
State Attorney's Office.
Sorry, wrong number.
Court reporter, Eric speaking.
Hi, Eric. This is Judge Brown in the Magistrates, which is room 4155. I want to start my extraditions. I put the system on, and the recording is blank. It's not green yet. So do you guys need to know I'm doing that?
Bear with me just a second here. How are you doing today?
I'm doing great, Eric. How are you and the fam?
Good. Just getting ready for kids to be out of school and all that
Yes,
stuff.
lots of fun.
They want to come down and hang out again.
Hey, listen, it's, you know what I call it? Court camp.
Pardon?
Court camp. Hi,
Yeah.
Mr. Farnsworth.
Okay, let me see here what's going
Good afternoon.
on. And you're in 41, which room again?
4155. It's the magistrate hearings.
Oh, okay.
I mean, it's extraditions right now.
Oh, okay. So that's where Malika is. Okay.
I mean, who fires it?
I thought that usually was turned on.
I do have the system on, but the light is not
The blue light's
lit.
not on?
No.
Okay, because we were having some technical difficulties. Okay. So let me just go through here and see what's happening. Just
it was working fine this morning.
Yeah, well, it went down around 11 or so.
Oh, you're right. It crashed while I was in my other courtroom. That's right.
Okay.
That's right. They called to tell me that. But it came back up. It did get the tail end.
4156 is where I see you in here, right? 4156?
55.
Or 55. Why did they have you as 56? It's weird. Okay, 4155. Okay.
That is so
Let me see. I'm not seeing it.
Okay.
Okay, let me do this. Let me run out there and find someone.
Please, and I'm just going to keep my system on, and as soon as the light comes on, I'll start talking. Okay?
Okay, and you're on the bench there, 7761. If we need to call you back.
Yes, it looks right.
Okay.
Thank you.
Okay, I'll figure it out. Okay.
Thank you, Eric. You're a doll.
You're
care.
welcome, Judge. Anytime.
Thanks.
Bye.
Okay. Now, Mr. Farnsworth, you know how when you have me as your judge, I'd like you to do it, tell every these nice folks, because I have this little cheat sheet, but I like when you do it. Okay. And now I know that there's forms they can fill out, but I only have like one of each. Do you need me to make copies of these?
No, actually,
you have everything you need?
Yeah, actually, BSO.
Fantastic.
Because they're the ones that handle the paperwork.
Perfect. I just had this up here, and I wanted to be able to do my part, but now that you walked in, I'd like you to be able to, because you explain it so well.
BSO's not here, but anytime you want me to start, I can go ahead and start.
I just have to wait for the light.
Because we don't need
BSO right now.
for that part.
Yes, and I'm just waiting for the light to come on because it's recording, and right now I cannot say that it is recording because there's no proof of that. Okay, I'll watch for my phone to ring. Eric's going to call me maybe. Are you also in drop? Are you? Okay, wonderful. When's your end date? Same time?
Same day.
Oh, that's so great.
Yeah, Dale
how you doing?
This is the last day until July.
Okay.
So he had like
So much time.
2 months worth of vacation.
Wow.
So his last day was last Friday.
Wow, I didn't know. That's wonderful.
Yeah.
So many changes, so many people leaving. Yeah.
He's gone.
Yeah. Okay, I'm getting a call. Hi, this is Judge Brown. Hi. Very good. Well, let me turn it. It's not working on the off and on system the way you wanted me to do it. It's not working still. But yeah. Recording recording? Let her just at least let me know if it's recording even without the light so we can start. Yes, thank you. Okay, bye-bye. Fantastic. Thank you so much. Bye-bye. Okay, still not ready, but getting there. Momentarily, a girl named Debbie will return, who I believe is Debbie Garr, and she knows everything at court reporting. I believe this is Miss Lazarus that's on film at the jail.
No, the thing is not working. Fireman's dad is not here yet. Teresa's went to the extradition. Janae is coming. The extradition officials, that one of us should be in, but no, there's never money in the budget for those things. That's nice. No. Right. Right. And yeah, which is Mr. Grassman out of Tennessee, parole violation. That's him, but it doesn't say what. He had locals with us. Yeah.
Oh, hello.
He's been in our custody since January, actually, so he must have disposed of his locals.
Pre-signed.
Oh, that's it?
She can't start yet because the light's not on yet.
He had a 15 VOP, a 16, then his hold for parole violation, and then here's a manslaughter. Is that still pending, or should I dispose of? I don't know where it saves. Nobody has saves. Odyssey. She has Odyssey up. For Odyssey. 1808, most likely. It's actually sale something, deliver now.
Here's the warrant.
Oh, thank you, yeah. All right, we are on the record. Mr. Farnsworth, thank you so much.
Okay, thank you, Your Honor. basically up to you. If you want to waive or not waive.
Now, who calls the docket? I don't seem to have a docket with the names of those who are on an extradition list. Do you have the docket? There's only,
It looks like it's this one.
thank you, I wasn't given that, thank you so much.
Now,
Right.
there is one caveat, and that was John Grasmick. When, Your Honor, we already have a pre-signed waiver from him. When he was placed on probation or parole in the sea, he signed a waiver basically agreeing to not contest
Right.
any
So,
extradition.
Okay.
So basically, the same thing we're asking if you wanted to hear, you did when you were placed on probation. So
so you agreed to go back right away?
here's a copy of that.
He has a question.
Here's the order to sign.
Okay, thank you, I'll sign it.
That's just a copy of what he.
Okay, what he did in Tennessee? Yeah.
Well,
It's not that they wasn't.
if you resolve it here, okay, once the judge signs that, we will call their estate and say, hey, John Letty, he's resolved his local charges, he's ready to be picked up. We're not coming to get him, we don't want him, then we let you go right there. Whether, we don't wait the whole 30 days. You know, once we- It's costing money to house the teachers, or the program. Yeah.
Okay, I've signed the order.
But that's totally up to Tennessee, not to us.
Okay. All right, how about Melanie Mahfouz? Ma'am, do you have any questions? Oh, Mr. Farnsworth, you have more to say?
Well, one thing on Melanie, Judge, she has actually been in here before.
Oh,
And she had warrants from 3 different states.
I see.
She signed a waiver as to South Carolina, but it's now at the 30-day point for Minnesota and New York. So we'd be asking for the 60-day extension on those 2 states.
Yes,
Yeah.
that's correct. Well,
It's for those other states
You-
that have time to prepare the government warrants.
yeah, you haven't waived extradition to Minnesota and to the other.
Right.
Right, what happened is you had apparently signed for South Carolina, but you did not sign, I'm not really discussing it with you, I'm just letting you know what's happening. And that is, I think you said New York and Minnesota?
Correct.
You did not sign a waiver, and therefore they're now seeking an extra 60 days, as Mr. Farnsworth told you that they would, and I'm granting that.
Basically, it's done out of an abundance of caution. Your
Sure.
Honor, because what could happen, and a lot of people does, is that South Carolina may decide they don't want to take it.
Right.
And they would drop the hold. And then we would be pretty stupid if New York Pump said like, hey, you had that person,
Right. Yeah.
why'd you let her go?
So that makes sense to me, so but she can sign waivers though, and they won't have to do that.
Yeah, if
If you
wants
wanna sign
waiver of those other places,
For
that's
Minnesota
her.
and New
And
York, then we
basically it ends
won't,
up being first come, first served.
yeah. Do you understand? You have 3 different states wanting you. You've signed 1 waiver. The other 2 don't have a waiver, so basically they're seeking more time to bring you back with that governor's warrant, and I'm going to allow them to do that. If you sign the waiver, then they can get down here faster, hopefully, than the 60 days necessary. But you seem to be fine with not doing it, right? You're fine with that, right? Yeah, she's shaking her head no. She doesn't want to sign the waivers for Minnesota and New York. And so now what do we do with that? Anything else? That's it?
We have the extension order.
Yes, I need 2 extension orders,
Yeah. And then
because they're different case numbers. One ends in a 4, one ends in a 3.
I'll have those for you in just a second. Your Honor.
No problem. Can I continue with what I'm doing now? Brady Nelson? Hi, Mr. Nelson. Understanding that if you waive extradition, they'll get here faster than if they have to go through the trouble of getting the governor's warrant. Do you wish to waive extradition, or you do? Okay, Mr. Nelson would like to do a waiver. Okay. And do you have any other questions for us? Okay. How about Mr. Taylor? How you doing today? Now, did you understand if you waive extradition, they probably come get you faster, then they don't have to do any work to try to get a governor's warrant? Or would you like to have them get a governor's warrant? You'll waive? Okay, and did you have any other questions? I thought you had another question for Mr. Farnsworth.
I would ask them about the credit time, like with my time.
This does not count toward the other state. When you're sitting here, like this lady, Miss Mafu, she may be sitting here 90 days, she's not gonna get 1 day credit in the other states of Minnesota or New York or South Carolina, but that's her choice. Oh, no, once you waive extradition, you still don't get credit here, but they come get you faster, so you're not stuck here longer. That's the difference. They don't have to do any work to come get you, they just come get you. A governor's warrant takes time and the like. What am I doing here? All right, everything good with you?
Yeah, she's like.
Who is it?
Should be the defendant's name. Yeah, I mean.
Sometimes we see like, no, there's no paperwork, we see them reset, or if it's a violation of probation, we see them reset. This is
South Carolina.
No.
I don't have,
it's
yes,
not South, it's Minnesota and New York.
which one, who are you talking about, Gray?
So
Okay, we're talking about Gray.
Minnesota.
Okay, the jail just wants to know if
That's
they're
it.
gonna come over, I'll tell them not to go.
That'd be fine, he'll go see Judge Cohen tomorrow. Thank you for letting us know that, Eric.
And
Yes.
then New York.
Oh, ma'am, you've changed your mind? Miss Mahfouz has changed her mind, Mr. Farnsworth? She'd like
To waive?
to waive on Minnesota and New York, correct?
Okay, well,
Okay, and then so it'll make all states don't have to do the governor's warrant, so they can come get you as fast as possible. Absolutely, okay? You see, ma'am, what's happening is if you don't waive it, I've just extended it 60 days, and therefore they can take that long to come get you because they're working on getting a warrant by the governor. Oh, that could be a concern. They might have a case against you that you were not arrested for. Sometimes there's what they call a summons. Well, it's unfortunate. I don't know why they think you might have.
Because Minnesota's the one that has to prove the case. I don't. And I, therefore, also, it doesn't mean it's not any good to find any backup.
It doesn't matter either way, ma'am. They're going to come get you in 90 days or hopefully faster if you sign the waiver. You see, the thing is, they're going to come get you anyway, whether it'll be making you wait for a governor's warrant or, right, regardless. And thank you. I've signed these all. Do I give it to the clerk or to you?
yes.
Yes.
Okay, and I'm giving you back those papers or give these to the clerk as well? The state of Tennessee papers. Okay, there. Here you go. There's the 3 so far signed, my dear. Very good. And what else can I do on extraditions? She needs 2, right? She has 2, right, Deputy? Okay, good. Well, you already signed for South Carolina, so these are the 2 today, the New York and Minnesota, okay? But again, hopefully they'll come get you faster because you're not getting any gain time. The faster you get up there and resolve, whether it's not you or not, they're coming to get you one way or the other. It's just a matter of how fast. Thank you, and I wish you all the best of everything, truly.
Thank you, Judge.
I thank you for your explaining everything to everyone. It just makes it so much nicer than me. Always good to see you guys. Take care.
I don't mind doing it, Judge.
Because you know it by rote. It's by memory.
Yeah, I know,
And they left a file here that says extraditions. I'm going to leave it for Judge Malika.
to say they don't know anything, and I know that we've covered all
Exactly. And so I feel better too. Thank you again. Bye-bye. Now, thank you for your help, man.
See you guys.
Did we had Mr. Farnsworth's name on the record, and that was all we needed, right? All right, ladies and gentlemen, we're here for first appearances. I'm already ready at the main jail, but is Corey Lazarus at the main jail?
Yes, she is, Your Honor. And I
She's
think
here
if I
present,
should-
Judge. She is approaching. Come on up, ma'am.
She's here.
Yeah, they haven't processed.
I've understood Miss Lazarus,
Posted on this? Lazarus?
Corey Lazarus. Okay, ma'am, I do find probable cause for the following charges. Possession of oxycodone as $1,000 bond. Count 2, possession of alprazolam, $1,000 bond. Count 3 is DUI with alcohol or drugs as a first offense is a $500 bond. Count 4 is a DUI with damage to property or person of another. It's a $1,000 bond. Failure to use due care is no bond required, and no proof of insurance is no bond required. Ma'am, I did find probable cause, and if you'd like to bond out, your bond will be totaled. Well, as I just said, if you add that up, it's $3,500, and I wish you the best of everything. Thank
Judge,
you.
our only request is, would you sign an order allowing her to have access to her phone number so she can
Granted.
contact her friends and family?
No problem at all.
Thank you, Judge.
Thank you.
Appreciate that. Thank
Good
you.
luck, ma'am. Okay, James Charles.
Mr. Charles, come on out. Good afternoon.
Good
This bond has
afternoon.
been posted, Judge.
Okay, so
Your
Mr.
family came through for you.
So sir, I do find probable cause. You were arrested for the misdemeanors, but with a $1,000 bond, you can get out of jail, and I understand somebody posted it. Thank you so much. I wish you the best, sir. Make sure you go to court, okay? Thank you. Jamie or Jaime Vasquez?
Mr. Vasquez is approaching. Judge, as far as in reference to this case, count 1 is in out of county, but count 2 is a municipal ordinance, and the Public Defender's Office doesn't represent people in municipal ordinance.
That's correct, not city cases. All right, sir, you do have an out-of-county hold regarding a civil matter, it looks like. That's I believe it's an amount of money that might be $570.
Yes, ma'am.
Is that a 5 or a 6? $570. And also, you have a capias for a misdemeanor, municipal ordinance from a very old case. That's a $200 bond. So for $770, sir, you can get out of custody. And I wish you the best of everything. Probable cause is found for your arrest. Thank you, sir. $770, you can get out of jail. Thank you, sir. I wish you the best. Vladimir Isma.
Vladimir Isma? He's here present, Judge. Municipal ordinance case.
Your bond has been posted, sir, although I found probable cause on these two municipal ordinance violations. Sir, someone's already posted your $25 bond. I wish you the best of everything. Make sure you go to court. Thank you. Thank you. Johnny Tercios Martinez.
He's approaching, Judge.
Thank you. Good afternoon, sir. I do find probable cause for the following charges. Driving while license suspended as a third or subsequent offense, that is a $750 bond. Driving while license suspended as a habitual offender is $750 bond. There's been a capias on a traffic matter that has a $250 bond. Plus, they say you have a violation of your probation or community control, which is a no bond hold. So until you see that judge, you won't be able to bond out. There seems to be a status on June 12th. And also maybe June 8th on the VOP. I found a probable cause for the arrest, sir. I wish you truly the best of everything. Good luck, sir. Leon Tyrone Brine?
Judge, he bonded.
Very good, thank you. Probable cause is found by the court for his arrest originally. Robert Carl Faust?
Judge, I've been advised he bonded.
Okay. I did find probable cause for his arrest. Thank you. Now I'm going to look at my second looks. Does anybody else have anybody besides the second looks left? I don't.
No.
All right. So, which order do I call them in? Does it matter?
No,
Okay.
just me last.
What'd you say?
Just joking.
I didn't hear what you said.
Saying call the main last.
We like to keep Hector in the jail as long as
Oh.
possible, Judge, so we try and call his case as
Mr.
last.
Romero?
It does seem like that, Judge. It does seem like that.
All right. Well, it looks like there's some attorneys already. Like, for instance, Irina Flores, page 3 of the misdemeanor docket. Did you have Flores?
North Broward, I believe, Judge.
Okay, thank you. Irina Flores, is she there?
What docket is she on, Your Honor?
She's on the
We don't have her on our
second.
docket.
The second look.
For our second look, we only have 2 people, and her name is not on there.
And so, what do we do now?
Judge, in all honesty, Judge, I'd ask you not to take any action on this at this time.
Okay.
I remember when Ms. Flores came through, I thought we had sent her to Judge Lorna Wren.
No, we weren't able to do it at the time, but I can tell the court, she actually had a second look
May 11th before Judge Malika, and it was still, I believe she spoke to Judge Solomon about the case to make her aware of the case. There's other issues going on.
Okay, so do nothing today? She's just sitting in jail for 30 days already.
And that may become an issue later this week, early next week. I'm aware of that. But
so just delete it?
I would just ask the court to take no action.
No action is taken. Thank you. I want to use the right terminology. Okay, very good. How about Thomas Lenoy?
Conti, Your Honor.
And yeah, he's got actually the 3 MO cases on the misdemeanor docket and
Yes.
1 felony case.
Okay, very good. Now, page 3 on the felony docket, page 2 on the misdemeanor docket. All right. Hello, Mr. Is it Lenoy?
Yes, ma'am.
Very good. You, sir, yes, you have 3 charges that are, again, apparently the city ordinance violations of no lodging on city property. Hold on one second.
Okay.
I'm sorry, what? I transferred? I thought I did that already. Okay, it's fine.
She has 3 separate cases.
Ah, that's why.
Yes.
Very good. Okay, very good. Can you reach him? Okay, let's start this again. Thomas Lenoy, page 2 on the misdemeanor docket, and felony docket is page 3. Now, so you have the 3 cases of no lodging on city property, and then you also have what's alleged to be a possession of cocaine and drug paraphernalia. On the felony case, there's a motion for ROR on the felony cases.
Yes, well, Judge Malika kept all the bonds in place, which is a $1,000 bond on the possession of cocaine. The 3 capiases had $100 bonds each. I provided the court with a copy of the original probable cause affidavit.
Yes.
Also, I believe additional information that Judge Malika relied upon is that Mr. Lenoy is a registered sex offender. And I believe the court had some concerns about the failure to appear.
Yeah, how many times has he failed to appear? I mean, I know on these, he's failed to appear on the 3 no lodging.
Each one was on a separate date.
Yes, okay. Sir, apparently there's a concern for your appearing in court. Does the defense wish to say anything else? Other than...
Well, I can't represent him on the municipal ordinance cases,
No, but
Judge.
I mean on the one before me, about his failure to appear, things like that.
I don't know, Judge. I'm looking to see who's representing him at this point. Mr. Lenoy, do you know who your public defender is?
No, sir, I don't.
All right, let me see what I can find out.
Because I'm inclined to deny it, but I don't know if the defense wants to say anything that would sway me. So, Mr. Lenoy, you see, based on your history of failing to appear to court, I'm concerned that if you don't have a bond, when does he go into the division? Do we have a date when he'll go to court?
The MOs or the felony?
Felony? I'm only here on the felony, to be honest with you.
I understand.
But for the record.
It doesn't have a date set, but I just advised Mr. Reedy it's actually been set in drug court already. So
Okay.
I imagine he'll possibly see Judge Tobitson.
Sir, they actually wanted to send you to drug court, which I think is wonderful. But at the same, yeah, that's good. That's good.
I would like to go to that, man. These ordinance that I got, I did continue. I haven't continued, but I thought it was for May. My last one, the 18th of 2018. I thought it was May, but it was really April, and I missed it. And I tried to reset it, and I got picked up instead.
Okay.
I was supposed to go to court Friday, they said, and I got picked up, ma'am.
We actually sent someone out to interview Mr. Lenoy today.
Okay.
And so we don't really have a lot more information on his case at this point than we did when he came through magistrate court the first time.
All right.
I can advise the court that there are other issues involved with Mr. Lenoy.
Okay. Well, I'm going to respectfully deny you the motion to let you out on ROR, but they did put you in drug court, sir, so I'm hopeful you'll get something there that you need, okay? Thank you.
How long will it take before I can get home?
I don't know. You might want to ask the drug court judge. She probably can help you. I think it's Judge Tobin Singer, okay?
Because I'm trying to get back to Texas.
I'm sure she'd be happy to hear that.
Okay, man, thank you.
Thank you, sir. Good luck. All right, so as to the second look, do I need to say anything about the lodging cases or no? No, they still have a $100 bond. The judge has already made that decision, so here we go. Now, as to the next case on the misdemeanor docket is Charles Martin, page 3.
North Broward, I believe, Judge.
Hi, is Charles Martin there? Thank you.
Yes, Your Honor, he's coming.
Your Honor,
I see.
This is a second look. I believe bond was set at $5,000 on the stalking.
Okay,
I remember, this came up over the weekend, but I remember the case from Friday.
sure.
Based on just the nature of the offense
Yes, I'm
and the
reading
allegations,
the-
I'm gonna ask that this. go to
Remain?
Yes, please.
Okay, Mr. Martin, I'm taking a second look to see if I can do anything about the bond that another judge puts that you have to post. I'm finding, after reading this, that that is a more than reasonable bond. I think it's $5,000 each count,
I'd have to, if I could have.
because that's what I would want as the judge hearing the matter and reading the probable cause affidavit, finding PC, and
I can tell you, Judge, yes,
this is Mr. Martin, Charles Martin.
it was Judge Dennis Bailey this weekend. He set the stalking at 5,000.
I have 3 counts of stalking on my docket.
I know it looks that way. I'd refer the court to the probable cause affidavit.
Okay, which is usually not the one I'm supposed to look at, but okay.
Stalking is 5,000. The criminal mischief is 100, and nuisance injuries to health is set at 1,000.
Okay, so $6,100, sir, you'll be able to get out of jail. Good luck, sir. I wish you the best of everything.
And he has been interviewed by our office judge. Jeremy Michelson is his attorney. Mr. Michelson will be up to see you soon, Mr. Martin.
Good. Jeremy Michelson's a very good lawyer. Thank you.
Yes, he is.
Adam Sponsel. Where's he?
Mr. Sponsel is here, present, Judge, at Maine.
Very good. Hi, Mr. Sponsel. You've got a petty theft charge that, what's the bond on that?
He's got a $250
Judge, I believe
bond on
it's
the.
a $250 bond.
Okay.
My understanding is as a no bond holdout of Palm Beach County, it's a felony offense. Right now, he has no way of posting this bond. We'd ask you to consider an R warrant, the petty theft, so that Palm Beach County can pick him up on his felony offense.
And the items in this petty theft were recovered.
Okay, good.
I don't have a problem with that to move him along to.
Oh, that's fine. As long as you have no, the state has no objection, so I'll do it. I was going to ask this history, but since you don't have a concern with it, I'm fine. But Mr. Sponsel, you're going to note that this case is still going to be here. Okay, we still have the Broward case, even though I will release you on your own recognizance so you can address that Palm Beach case, but you must make sure that the court in Broward has your correct address and that you show up to your court hearings, or else they'll put you right in jail and you'll be sitting there till your case is done. It's just not in your best interest. So I will release on your own recognizance by agreement of both parties. All right.
Thank you, Judge.
Thank you. I wish you the best, sir. You want to give me a short order to that effect? Or who does the order? Oh, thank you so much. Now I'm going to go to the felony second looks. Tell me when you're ready, Madam Clerk. Okay. Page 2 is Edgar Chang.
North Broward.
Thank you. Is Edgar Chang there?
Yes.
Hi, Mr. Chang. There's a motion for your release of your own recognizance, possession of alprazolam, and possession of, I don't know, is it a buprenorphine? Yeah, it doesn't have the INE at the end here, so that's cool. And so these are felonies, obviously. I believe they're third degrees.
Yes, Your Honor, the state, this is a 30-day motion. The state has not filed an information at this
Okay.
time. He's entitled to an ROR.
It says 40 days, so and he is entitled to an R
Yes.
40.
Yes, Your Honor. We haven't filed information,
fine.
so he's definitely entitled.
Yes.
The only thing is he's got a $1,000 bond on a separate matter of grand theft, so that still will be holding him.
Right. I'm not doing anything more, Mr. Chang, but releasing you on case number 18004320CF10A. The other case is not touched by this court. I'm releasing you on your own recognizance only on the courts that counts of possession of alprazolam and possession of buprenorphine. Okay, do you understand? I'm releasing ROR. But now your other cases still have a $1,000 bond. I'm not touching that today. Thank you. I wish you the best, sir. Yes, sir, you have a question?
I can bond out?
Yes, sir, you
with
can.
$1,000?
That's correct. You can bond out for the other case. I've let you out on this one on your own recognizance. Make sure you go to court so you don't end up with a warrant and end up back in jail and not being able to get out. So please pay attention.
understand.
Make sure the court has the clerk office has your good address, okay? Good luck.
Thank you. Thanks.
We have a Patrick Hullinger.
Conte.
Hi, Mr. Hullinger.
Hello.
This is a motion for ROR regarding a burglary of a structure occupied as well as a grand theft third degree.
This is also a 30-day motion under the state. Has not filed information, so he's entitled to release on these 2 counts. There are some other counts holding him with bonds.
Okay, that's fine. Sir, on this case and this case alone, 18004476 CF10A, I am going to release you on your own recognizance, but please remember, you must address these charges. They have not gone away. Make sure the clerk's office has your correct address so you can get the notices for court. But the other cases that you have are still pending. So you have bonds to make on those other cases, okay?
Thank you.
Good luck, sir. Good luck.
Thank you.
Now on James Turner.
North Broward.
Hi, Mr. Turner.
How you doing, Liv?
I'm doing fine.
Great.
Everything else is a second look at this point.
Yes, I was going to say it's only 11 days. All right, what is the bond the judge originally wanted on this case?
It's a $1,000 bond on count 1, Judge.
And count 2?
No bond required.
Okay, fine. There's a motion by somebody.
These were all set by pretrial pursuant to administrative order.
Okay, but the public defender's not representing them, because I don't see a public defender on this case. The other ones I saw a public defender. All right, so just to take a second look, sir, what is his history?
Your Honor, as far as his local state priors, 2014 battery, 2013 disorderly intoxication, 2 thefts in 2013, trespass 2013, theft 2012, disorderly intoxication 09.
Let me ask Mr. Turner, do you have an address, a home?
Yes, and all them charges, I beat him with a lawyer.
Okay, well, apparently they believe they just happened on May 26th, okay? So this is not the same that you already beat, because these aren't filed yet. May 26th of 2018, there's an allegation that you possessed cocaine as well as drug paraphernalia, supposedly in a vehicle. They say that in the vehicle, they found crack and a crack pipe. Now, pretrial, are you interested in taking him, or?
Only if the court orders it.
Okay.
We did not place him on because we looked at him and investigated him.
Okay.
We placed him on purely pursuant to the ADO.
Okay, very good. All right, sir, so you do have a history. I'll go ahead and reduce it to $500 bond. Hopefully you can get out with that. I think you need a bond, though, based on your history. Thank you, sir. I count 1 only, a reduction in the bond to $500. Good luck, sir. I hope you can bond out. Thank you.
One more question, ma'am.
Sure.
This is a charge that just come up, right?
Yeah, they said you were in a car. They stopped you. If I remember correctly, they said you weren't wearing your seatbelt. The officer stopped you, and he said in plain view he saw laying on the center console of the vehicle what was a crack pipe, and he field tested it positive for crack cocaine being in the crack pipe, and thus you have the charges now. It's new charges. But it's all an allegation.
Now, last week, I went for a second look, and they gave me probation.
No, sir, that didn't happen at the bond hearing. I don't know if somebody else did, but this is a different case, and I've reduced it to $500. Thank you. Good luck, sir. Gregory St. Fleur.
Conte.
Thank you. Gregory St. Fleur, please.
Yes,
Good afternoon, sir. It looks like I guess pretrial's got a motion for ROR. Sir, you have a possession of cannabis charge as well as a possession of MDMA, which is known as ecstasy, and a trespass, failing to leave a property after being told to do so. So now the question is, what is this bond now?
Looks like no bond required on counts 1, count 3, 1,000 on count 2.
All right, so your bond is $1,000 for count 2 only. The others are not requiring a bond.
Okay.
So you can get out if you can have somebody post the bond. What's the matter?
No, Your Honor, the reason why it appears the reason why Judge Malika left the bond in place was Mr. St. Fleur was arrested about 2 weeks prior to this arrest for battery, criminal mischief, cocaine, possession of cannabis. He was released on pretrial. I don't know if any action was taken.
Okay, to revoke it?
Yeah, I don't know. If, I'm guessing a warrant was probably brought to
some judge. Yeah. All right, Mr. St. Fleur, having heard that, I do believe $1,000 is a very reasonable bond for this particular charge. And if you can post it, then I believe, don't forget, sir, to make sure you show up to court and make sure the clerk's office has your correct address so you can get notified. I hate for you to miss court and have them put out a warrant so that then they'll have to put you back in jail, and I don't want that. So please make sure you get to court, okay? $1,000 bond is still in place. Good luck, sir.
All right, thank you.
Thank you. I wish you the best. Nicole Pearson.
North Broward.
Hi, Miss Pearson. Good afternoon. Can you hear me? I cannot hear you, however. Thank you so much. Okay, very good. Ma'am, there's a motion for ROR regarding a grand theft of $10,000 or more, but less than $20,000, a petty theft in the first degree, as well as resisting or obstructing an officer with violence, which is a felony of the third degree. And what is the bond at this point?
Bond's 1,000 on count one, 100 on two, and 500 on three.
I'm sorry. Say it again. I misunderstood. 1,000 for count one, 500 for two.
100 on two, 500 on three.
Okay, very good.
And there's also some, and I believe I provided the court with the probable cause affidavit.
Yes.
There's some sensitive allegations.
Yes.
I think that were
I read
cause
that.
for some concern.
Of course. Ma'am, so it's a total of $1,600, and based on the charges and the nature of the charges, I don't know of a reason to reduce that. Let me see if there's anything that happened that I need to know about. All right, let's see. Yes, I believe that $1,600 is a reasonable bond under these circumstances, and I'm going to leave it as is, ma'am. Do you have anybody you can call to help you?
For 1,600.
It's $1,600, but if you can get a bondsman, it's 10% usually, or so I'm saying, so if you can call someone to try to help you, that would be advisable, okay? And ma'am, please make sure that if you do get out of jail, you do come to court so you don't end up back in jail for missing a court date, okay? Make sure the clerk's office has your correct address. Hi, Meredith. So
and if I don't get bailed out, then what happens?
You'll go see the judge that's assigned to your case. It'll be a felony judge. I don't know who it's assigned to. It's only been 6 days, so they have some time before they have to file it. But do your best to get out of jail, okay, ma'am?
Yes, ma'am.
I wish you the best. Good luck.
Thank you.
Wiltron Thomas.
Mr. Thomas is here, present. Judge O'Mahony is approaching.
Thank you. Hi, Mr. Thomas. Good afternoon. Now, it looks like they have the 1, 3, 4, and 5 are counts of burglary of an unoccupied conveyance, which is a car. What is the bonds at this point? They're third-degree felonies, so I'm imagining they're not that high.
Mr. Thomas
$20,000, Judge.
So they're $5,000 each?
That's what Judge Bailey set them at, yes.
Okay, Judge Bailey did. What's his history?
One moment. I'm going to need a moment to...
You can have a moment.
And Judge, while Mr. Lender's looking up his history, if I can give you a little background, Mr. Thomas is 19 years old. He's not working. He's going to be graduating from high school, from North Park High School, which is located in Opelika. This Thursday, from what he informed me, is his ceremony. He lives with his grandmother. His grandmother's raising him, and unfortunately, she's elderly, and she only receives Social Security, so she cannot afford the bond. Judge, we'd be asking you to consider even a higher form of supervision, potentially level 2, so that he can attend his graduation, because right now there's really nobody that can post his monetary bond. And so that's what we're asking for, Judge. Judge, in the alternative, if Your Honor is reluctant just to straight out release him on pretrial, we'd be asking you to consider on counts 3, 4, and 5 in a reduction in bond, potentially from $5,000 each bond to maybe $1,000 each bond. Now, I did review the probable cause affidavit when I looked at Odyssey.
Yeah.
I know the court is bound, the probable cause was already determined, but when I read the probable cause affidavit, my understanding is, Judge, apparently on count 1, there's an eyewitness that sees and identifies Mr. Thomas allegedly committing count 1. Later on in the probable cause affidavit, I guess 3 other victims just show up and just inform the police that their cars were also burglarized, but nobody actually saw Mr. Thomas enter that vehicle. No property was recovered. So I don't even know as far as what's the likelihood of those cases even filed without more additional information. I'd ask you for mitigating purposes to consider pretrial release on it, or if the alternative, a reduction of bond on 3, 4, and 5.
Well, your argument seems to be well taken. However, let me hear his history, even as a juvenile. And believe me, Mr. Linder, I will not be making a decision without hearing that information.
I appreciate that.
Of course.
Your Honor, I'm just so we don't have to provide information out over the internet of a juvenile nature. I'm just printing out two DJJ reports for Mr. Reedy and Your Honor that covers his history.
And the real part for it is whether there's any failures to appear. If that's something
that will be in there.
It won't be. It will, right? Yeah.
If there's ever been a pickup order, it'll be in there.
That's what I'd like to know.
I can tell you, Your Honor, while I'm putting this together, there is a warrant for his arrest out of Dade County from April 16th of this year, $1,500 warrant for failure to appear and operating without.
Okay. Well, that's the concern I had. Is he going to show up to court? And that's why I was wondering about that as to his concerns. But I want to be able to know he's going to appear in court. And that's what the bond is, to assure his appearance, as well as other things.
Your Honor, frankly, my greatest concern just looking through this at first glance is just seeing how many times secure detention was ordered on his juvenile cases.
I understand. And Mr. Romero, unfortunately, you don't have the benefit of seeing what I'm looking at. I know Mr. Reedy does, but at the same time, he has a lengthy history.
I understand the court's concern, and Judge, that's why I'm not asking for standard. I was even going to be willing to go ahead and do level 1 house arrest with an Elma monitor, just to allow him to go to his graduation. And once he finishes his graduation, comes back, if for some reason he runs, pretrial is going to know right away there's going to be a warrant out for his arrest, and then he's going to be sitting here no bond. I'm just thinking high school graduation.
Respectfully, your motion is denied. That remains at the $20,000 level. $5,000 each. Thank you. Good luck, sir. I wish you the best. There's that warrant again in Dade County, but he has to remember that.
It's Dade County pickup.
Yeah. Oh, it's pickup. Okay. Ile Bensis.
He's here present, Judge, at Maine, and he is approaching, Judge.
Thank you.
Good afternoon, Judge.
Good afternoon, sir. This is regarding the case of a possession of heroin. What is the, is it $1,000 bond?
It's a $1,000 bond, Your Honor. If I recall, Brian, correct me if I'm wrong, there was a lengthy conversation where Mr. Bensis was going to be offered pretrial, and then he said, you know what, I'd rather just bond out.
I do believe that's
That
correct.
That's absolutely correct. He informed me that his friend was going to go ahead and be able to post his bond. He thought his friend had $100. When he contacted him, unfortunately, his friend lost that money, and now he's in this position.
Okay.
My understanding, Judge, is that he's right now living in Delray Beach. He's working. He's working for a company called Pickup Movers, which is located in Miami. We're going to be asking you to consider releasing him on pretrial release, Judge.
And Your Honor, in full candor and fairness,
I don't have a problem if
yeah,
that's
that
what
was
you
going to
guys
be the
wanted to do.
that was
Sure.
made available to him the other
Exactly.
day. He should still.
So, sir, you'd like to be on pretrial at this time? Sir, Mr. Bensis, you'd like to be
Oh, they work
released?
with me earlier? Yes, ma'am.
Okay,
Yes,
just,
Your Honor.
you have a current address and phone number?
Yes, Your Honor. After 6 years, Your Honor.
Okay, wonderful. So I have no problem releasing him onto pretrial release. Just make sure, sir, that they have all the information, that you appear at all your court hearings, because otherwise you'll be ending up in jail again, and that's not what you want. Okay.
And Judge, I'll give him the map, and he'll have to report, because by the time he gets released, it's going to be close. He'll have to report to pretrial tomorrow before noontime.
And that's fine, but sir, I'm going to absolutely put some conditions on your pretrial. No alcohol, no intoxicants, and you'll be drug screened at least twice a month. And you'll have to call in. Is that okay?
Yes, Your Honor.
You cannot test positive. You'll end up back in jail. Do you understand?
Yes, Your Honor. Your Honor, yes, sir.
You may.
If I choose to enroll into a long-term inpatient program, would it be possible for a social worker from the program to contact you guys and let you know that I'm in a long-term inpatient?
I have no problem with that, but pretrial, would that be okay with you? As long as.
It probably would be best for him before just going to do that to let us know ahead of time.
Right. What you're going to do, sir, is you're going to get out on pretrial release. You're going to sign the agreement to do that, right? You're going to go speak to the social worker and to go into the facility. You're going to tell your pretrial worker that you're doing that, and then the social worker can call and let them know that you actually did do it, okay? So it's fine.
Excellent. Thank you so much. That was my intention.
And I'm hopeful, sir, that it helps you and that you are well. I wish you the best, sir. Thank you.
Thank you so much, Your Honor.
You're welcome.
There's a report there tomorrow before noon.
Sean Shirey.
Mr. Shiley is here present, Judge, at Maine.
Thank you. Hi, Mr. Shirey. The grand theft charge, what's the bond on it? Is it 1,000?
Judge Bailey reduced the bond to 500.
Oh, it's down to 500?
Yes, he does have a history
of failing to appear?
That I'd have to check. As far as history, though, he put out a possession of cannabis and paraphernalia a week before this arrest. He had a loitering and prowling that he put out May 20th, and that involved being on someone's property, allegations that he was touching someone's garage door, even though there was not an attempt to open it. This involves someone's bike that was stolen. There was a paraphernalia from March of this year. Then you got to go to as far as Broward, 2012, resisting without violence, dealing with stolen property, grand theft, 2012.
All right, thank you. That's enough. I think $500 is a very reasonable bond, knowing your history and the fact that you just recently had been arrested and bonded out or got out, and now they allege you have a new offense as of just Friday, June 1st. So I think $500 bond is reasonable under the circumstances.
Judge, the only thing I'm going to be asking, well, two things I want to inquire. The second count, besides the $500 bond on the grand theft that he has a $250 bond for petty theft. Before I came to court, I was trying to look in Odyssey, where's that from or anything like that. I couldn't find any information on that petty theft, so he has a total of a $750 bond holding him right now.
Let me see. I don't have that on the PC that's for the case.
It's on BSO Picks.
The PC has one count of grand theft regarding the bicycle?
Correct. And one other thing.
Hold on, Hector. The clerk, Madam Clerk, is going to provide us with some information.
No problem.
Okay, we received an email in regards to that second charge of the petty theft. The defendant was magistrated over the weekend for that charge. It is a new charge, and the case number has.
So it's a separate case.
I didn't even find it in Odyssey as far as the facts of that case. I found the facts of the grand theft.
Right.
And the reason, what I was going to bring up regarding the grand theft for Your Honor to consider as far as mitigation purposes, it's a grand theft. It's a third degree. Obviously, the value of the item $300 or more. But when I read the PC affidavit, it never said anything as far as the value.
I know
So
it does,
therefore,
right?
I know I can't object to.
It's the second line. It says it's a Giant Cypress LX serial number, and then it says $600 next to that. Yeah.
And I withdraw that.
Okay. I know sometimes I miss the numbers too. I don't know why.
I missed it.
Numbers,
I missed it.
all the numbers go together.
I don't.
No, you don't, Brian. You're perfect. But, sir, I do believe $500 is appropriate, knowing the last time you were arrested. Now there's another charge. So $500, I think, is a reasonable bond under your particular circumstances. Good luck, sir. I wish you the best. Michael Catania.
Mr. Catania is here, President Maine.
Sir, this is regarding the burglary and unoccupied structure, some burglary tools, possession, and burglary of an unoccupied conveyance, as well as the possession of cocaine charge. All of these are third-degree felonies. Are they all 1,000 each?
No.
No, Your Honor. Count 1 is 5,000.
Okay.
Count 2, no probable cause was found.
Okay.
Count 3 is 5,000, and count 4 is 1,000.
Okay, so let me ask you a question about his history and failures to appear.
Yes. Well, as far as history, he's out right now on a drug paraphernalia. It's a couple drug paraphernalias from last year. Possession of cocaine 2016, 14.5 months state prison. Possession of cocaine 2015, received the same sentence concurrently. 2015, another cocaine, same sentence. Theft and criminal mischief 2015. Attempted burglary of a structure 2014, 13.5 months state prison as a habitual offender. Possession of cocaine 2011 and 2010. Armed burglary of a dwelling and 2 counts of grand theft in 03 with a VOP, 2-year state prison.
All right. Anything about failure to appear?
I'm checking that right now, Judge. When he was arrested May 10th this year on the new paraphernalia case, he was also arrested on capiases, misdemeanor capiases. He was arrested April this year, again on a capias on misdemeanors.
All right, Mr. Catania, it looks like they have a record of you failing to come to court, and that concerns the court. We always want to make sure you appear in court to your hearings. You know, that's when we give the bonds, it's not only to assure the safety of the community and yourself, but to make sure that you will appear in court.
Your Honor, it wasn't that I didn't fail to appear. I was in custody at that time.
Okay.
But they never notified that I was in custody. So when they released me, and then they issued a warrant on me. I had no idea that I had a warrant for those 2 charges. One was a municipal charge and one was for during the hurricane.
Okay, well, what did you want to say,
The
Mr.
flip
Linder?
side is, it does not appear from what I could tell that I could check, but it doesn't. I don't know that he was necessarily in custody in Broward. So the flip side argument is, if he's getting himself arrested in other places.
So, sir, it might have been you were in custody in another location? You know what, the problem is, sir, it doesn't look like you were in custody in Broward according to the prosecutor here.
I could check, Your Honor.
No. They believe you might have been in custody in another city or state, and therefore they're concerned that while out of county and out of city, that you might be getting into trouble in other places. The concern, sir, is that there'll be no further criminal activity, that you'll be, unfortunately, you've had prior possession of cocaine cases, and now there's an allegation of another one. I believe that the bonds are reasonable at this point. As to count 1, it will remain $5,000. Count 3, it will remain $5,000. As to count 4, it will remain $1,000. I wish you the best, sir. I hope you get to bond out, a total of 11.
Judge,
Yeah, 11,000.
my understanding is he's homeless, but he is working. He has a mailing address in our community. Judge, if you won't consider pretrial release, or if that's not appropriate in this case, would you consider maybe a bond reduction? I know the possession of cocaine, it's a residue case, if you're aware.
Yes, I read that.
Most likely it's going to be filed as a paraphernalia. It's not going to be filed as a felony offense. Would Your Honor consider a bond reduction?
Respectfully denied, based on his history of cocaine. And that's it. You know, basically it's just another charge. Thank you, everyone. Always a fine job. Thank you. Bye, Mr. Reedy.
He's already up the door.
No, he's gonna be.
Okay, bye. Debbie said hi. Say hi to Debbie. All right, everyone. Take care.
All right, Judge.